Okay, thanks everybody for coming. I'm gonna step into the screen here. Um, this afternoon to this discussion on legal developments in reproductive health care. My name is Blake Rocap. I'm the director of the Reproductive Justice Defense Project at the Rappaport Center for Human Rights here at the law school. And I'm really overjoyed to be joined by Professor Rachel Rebouché, who's the G. Raleigh White Teaching Excellence Chair in Law. For the last 4 years, Professor Rebouché has been the dean at the Temple Beasley School of Law. She's truly a leading scholar in reproductive health law and rights and family law. She's the author of numerous scholarly articles and commentary on abortion law in the United States and reproductive rights internationally, including the article Abortion Pills, which was in the February 2024 Stanford Law Review, which she was also kind enough to share with us in the fall of 2023 as part of our reproductive justice colloquium. If you're interested in that, the recording of that talk is on our website, which is utexaslaw.edu/RJ-defense. So today we're going to have sort of an informal conversation about recent developments, both in legislation, litigation, and maybe what's coming down the pipe for access to reproductive health care. And then hopefully we'll have some time to take some questions. So without further ado, I kind of wanted to share a fact to ground us in what we're discussing today. And that is that the same number of Texans have gotten abortion care since Dobbs and the total prohibition on abortion went into effect in Texas than they did before that change in the law. And so I think that fact is driving a lot of the developments that we're going to talk about and that we see in changes in policy and litigation strategy across the country and in Texas.
So let me just say that Blake is being very modest because he didn't introduce himself. Maybe he needs no introduction, but for those of you who have not met or worked with our fearless director of the Reproductive Justice Defense Project, Blake has been one of the leading lawyers in our country for over 20 years, legal director for Jane's Due Process, which represents the interests of minors, and counsel for NARAL Texas, which is now called Eval, and of course, leading the project here. And so what we thought we would do, welcome, Blake.
Thank you, that's very humble.
Yeah, I'm impressed. Are you impressed that I know your bio so well off the top of my head? What we thought we would do is, as a division of conversational labor, Blake would focus on developments here in the state, some of the projects that we have been working on as a project. And I want to say, before we begin, I want to give a shout out to Professor Lauren, who's here, who's also been a big part of our project, expert in criminal law, and has led the criminalization efforts that the project has worked on. And then we're going to ask each other questions, and then I'm going to address more of the national developments, particularly in regard to the FDA, medication abortion, and as Blake just suggested, what has really been a driving force for much of what's happening on the national scene is the regulation or the attempt to impede mailed medication abortion. So there's lots of other issues to talk about that include family planning, fertility treatment, maternal and maternal morbidity and mortality rates. So lots to cover. We can only cover a little bit of it, but why don't we kick off with some Q&A between us? And then we'll open it up for questions. Because we're a small group, I think that if anyone has a question as we go, just raise your hand or signal that you want clarification or have a follow-up or interested in a topic. Okay.
You invited this, but I'm a sociologist, I'm a professor here. That statistic that you gave us, that the same number of Texans have had abortions post-Dobbs, what's your source? I would love to refer to that source.
It's We Count. It's funded. It's a joint project, but it's housed at the Society for Family Planning.
Yeah, it's a nationwide study of across all states of the incidence of abortion in the United States. Yeah.
And actually, I think that, if you add what they estimate for the number of people traveling outside of the state and then count the pills being mailed into the state, the most recent number suggests that more abortions are happening in Texas than happened before Dobbs. And that's true nationwide. The average number of abortions in the United States is higher than it was before Roe was overturned. So let's kick off with what's been happening in the state of Texas. Blake.
Thanks. So the legislature, as you guys know, meets every 2 years, and they just finished their biennial session finally after several special sessions. And they kind of did two major things with regard to access to reproductive health care. They codified the Supreme Court's Zarowski decision, which said that the medical emergency exception could be applied even when the harm to the pregnant person wasn't imminent, or their death wasn't about to happen, or that harm didn't need to have befallen the patient before a physician could intervene and terminate the pregnancy to prevent that risk of harm. So they codified that interpretation that the Texas Supreme Court had previously made of the law, and also shifted the burden of production and proof really to the state as far as who would have to prove that a medical emergency existed. And basically the state would have to prove that there was not a medical emergency, as opposed to previously the law was written where the physician would have to prove that there was. So that shifts the risk in some significant but subtle ways, I think. And then the other thing they did was pass House Bill 7, which is sort of a direct attack on this access to abortion care through medication abortion by mail or other delivery. And I think to understand how and why House Bill 7 exists as it does, you need to understand a little bit of the history of what's going on that Rachel alluded to, which is for the past 2 years or so, we've been at this uneasy detente of people traveling for abortion care, people receiving telemed abortion care into the state of Texas, which has resulted in a flat, if not slight, increase in people's overall access to abortion. And so the ultimate policy goal, of course, for some folks is to prevent abortion. So kind of faced with this fact that what these kind of 3 different bans that are currently in place haven't really done that, they were kind of really trying to puzzle through where they could achieve their policy goals and how to stop the abortions that they don't like that's happening, right? And they have a real problem with preventing people from traveling, right? And that's a major way Texans are still getting care. To the extent they can travel, go to see physicians in person in other states where abortion remains legal. But travel bans are problematic in a couple different ways. It requires a kind of level of monitoring and surveillance that's really distasteful to everyone. So it's quite politically unpopular. In addition to being like practically impossible to stop everyone driving out of state to see, are you pregnant? Are you tracking them? Are they going to come back pregnant? Like it's a non-starter to figure out how to do that. And it's got some real other legal problems. It's kind of constitutionally troublesome. Justice Kavanaugh, in his concurrence in Dobbs, says, nothing we're saying today has anything to do to implicate the right to travel, and sort of kind of lays down the marker that like, okay, states, you can ban abortion within your state, but you can't trap people in your state, right? Was the implication of his concurrence, right? So then they're left with, how do we prevent like medication abortion that's being mailed into Texas, either by shield providers or other pill networks in the US or out of the country? And House Bill 7 attempts to prevent this in kind of 5 different major ways, I think. And it attacks sort of the failures of the current abortion bans to prevent this from happening in these ways. So first of all, the current abortion bans really prohibit the provision of abortion within the state, and they prevent the prosecution or any penalties against the pregnant person. So it's been quite difficult for them to find actual facts on the ground that they can make a case out of, because they can't pursue criminal charges against what you'd think of as the primary witness to the crime, which would be the pregnant person themselves, right? And so what they've done in House Bill 7 is really, and it's unclear if like the current bans really apply to out-of-state physicians like mailing the medicine, right? So what House Bill 7 does is it makes this specific prohibition on the mailing of abortion pills into Texas, right? So then they don't have this kind of substantive problem about, does this prohibition apply to the act that's been done? They've very squarely put what physicians out of state are doing as prohibited, like within the bounds of the prohibition. They also, similar to Senate Bill 8, have made the prohibition enforced by a civil cause of action instead of some sort of criminal cause of action. This probably allows them to overcome any jurisdictional problems because the civil courts kind of have a longer reach of personal jurisdiction in some ways, and it's kind of seems clear that the physicians who are providing care into Texas meet that minimum contacts standard for personal jurisdiction. They also, by creating the civil cause of action, they've also expanded the class of plaintiffs that can sue and enforce these prohibitions. They've currently been trying to prohibit the provision of medication abortion through using other civil statutes like the wrongful death statute specifically to say, okay, what you've done violates the wrongful death statute, but the wrongful death statute has a narrow set of plaintiffs that have the right to sue under it. So they've expanded this class of plaintiffs to basically everyone, not just family members of the person who has the abortion, right? And that, and then the fourth thing that is innovative but maybe constitutionally questionable is that the prohibition is also on any intent to mail or prescribe the medication into Texas. So that allows them again to create a lawsuit not based on any specific act by someone out of state or any specific activity, but by alleging someone had the intent to do a thing that violated the prohibition, which with, so you can see how that helps them out in creating the case, which all leads to the idea that this legislation, although it's really intended to prohibit the provision of medication abortion, it really needs to create this litigation and in order to get there, right? So it really needs to create this conflict of trying to enforce Texas's prohibition against other states' shield laws in order to set up this these several different questions about the relationships among the states to be adjudicated. So as much as it's about the specific prohibition, it's really about getting the case in a position that can further allow Texas to expand its prohibition on abortion everywhere else.
So it might be useful here to pause and just talk a little bit about what shield laws are. How many people in this room have some questions about what is a shield law? Okay, so shield laws are in 22 states, either by executive order or by statute, are laws that seek to protect providers and those who help providers, offering legally protected reproductive health care. And states define that in varying ways, but all states that have passed these laws include in legally protected reproductive health care, abortion care, contraceptives, and most of the states at this point in time also include gender affirming care. And the idea behind a shield law is to protect people from out-of-state criminal, civil, and professional disciplinary attack if what they're providing is legal in their home state. So, for example, and we can talk about this in a little bit of detail as we talk about how these shield laws have come under attack and why, as Blake says, HB 7 is part of a national conversation about the legitimacy of shield laws and what states that have banned abortion are doing in response to shield laws. So a shield statute, for instance, says that New York, which has one, will not extradite anybody who's providing legally protected reproductive health care. So when a Louisiana grand jury indicts a New York provider, which has happened, for mailing pills into the state of Louisiana, or is alleging that the provider has mailed pills into the state of Louisiana, that person, as you know from your crim law classes, cannot, or criminal procedure, has to be in the state to stand trial. There's no default judgment against someone in a criminal suit. And to get the person into the state, they have to be extradited. If they're in New York, New York needs to force the person to Louisiana, and I'm oversimplifying. The shield law says New York won't do that state officials and state agencies are not permitted to extradite if there's a criminal lawsuit, which is what's happened in New York with the AG and governor of that state saying, we're not extraditing anyone accused of a crime for providing legally protected reproductive health care. Another thing that shield laws do is they protect people from civil investigations. So if the same provider in New York is sued in, let's say, a Texas court for a violation of Texas abortion law and has a judgment entered against them as a civil penalty, the shield law says we're not participating in that lawsuit from soup to nuts. So we're not participating in subpoenas, we're not participating in discovery, we're not participating in even filing a motion to effectuate a judgment entered in another state's court if the person was providing care that's legal in New York. Now, this is something we can talk a little bit more about because that last part about not entering a motion, not contemplating a motion to enforce a judgment has raised questions about how and when states should recognize the judgments of other states, which implicates, refresher from your con law class, the full faith and credit clause. And so the last category of coverage that I'd mentioned for shield laws, they also protect people in the shield state from professional discipline from outside the state. And that is licensure, discipline against, let's say, a doctor. Where, and this is something else we're seeing play out, where a state says you're practicing without a license, a medical license in Texas, by mailing pills into this state. We want to suspend your medical license, but the person doesn't have a Texas medical license. They have a New York medical license. Well, the shield statute says we're not going to recognize any disciplinary action from another state, which I mention here just because that's really significant for providers. Typically, states have, and we can talk about this being true also for instances of extradition where someone is not fleeing from justice. Typically, in the professional disciplinary context, states cooperate when one state has a disciplinary action against a provider who has a license in another state. But shield laws are exceptions to that reciprocity, and saying we will not suspend someone's license in this state, revoke someone's license, or allow for their medical malpractice or other insurance costs to go up or down, and it'd be up, but to go up, it will not change is what they do, but it would be to not increase because of an infraction, an alleged infraction in another state. So that's a broad overview of what these laws do. The first one was passed by Connecticut shortly after Dobbs was decided. I'm sorry, shortly before Dobbs was decided, and other states have quickly followed suit. The shield provisions that HB 7, in the way that Blake described, really target are in 8 states. 8 states have that definition I told you about, legally protected reproductive health care, defines that health care regardless of patient location. So that's what providers and those helping providers in these 8 shield states look to when they interpret what they do in mailing medication abortion across the country, because their shield statute says what they're offering in terms of protected health care is regardless of patient location. And so that has really been what has been a focus of national and state activity. HB 7 is the first state statute to explicitly target shield provision. And to underscore the point, we count the study I mentioned to our colleague, estimates that shield providers mail over 12,000 packets of pills a month, and they mail them across the country. So, yeah.
Yeah, thanks for that. So I want to think about the kind of go deeper into the basis of how shield provision works beyond the shield laws. So Texas is now attacking the shield laws, and that's one level of getting at this policy goal of preventing abortion, right? But this is really only possible because the FDA reformed its the requirements for the provision of medication abortion and removed the in-person requirement and the requirement of physician provision. Many years ago, medication abortion was really only available in person from your physician. Only physicians, it was part of this big kind of compromise of FDA approval many years, more than 30 years ago, that you had to see a physician and the physician was the one to give you the pills. It wasn't dispensed by the pharmacy. And that changed. And that ability for pharmaceutical dispensation, including pharmaceutical dispensation through the mail, right, is really what makes this possible in some ways. And the shield laws make it possible across state lines into like states with bans. So what are the other kind of ways that this ability for pharmacies to provide mail pharmacies and physicians to mail the Mifeprex regimen being attacked?
So just more as background, if interesting, and just, you know, get a kind of like start shaking your head no, if not. It's just like too much detail. You're like, move it along, move it along. So medication abortion is a 2-drug regimen, mifepristone and misoprostol. And mifepristone is the drug that terminates a pregnancy. It's the only drug that misoprostol can too, but it's the only drug approved to terminate a pregnancy. Misoprostol works by clearing the uterus. Mifepristone works by blocking the hormone that allows a pregnancy to develop. And in 2000, the FDA approved mifepristone, that first drug in a medication abortion, to end a pregnancy with the restrictions that Blake mentioned. The program for how the FDA administers those restrictions changed a little bit, but by really 2016, the FDA was implementing a set of restrictions on mifepristone that really didn't bear out in the studies of mifepristone safety or efficacy. So it was one of the first, it was the most significant first change in these restrictions, or REMS, a risk evaluation management strategy, and allowed other, healthcare professionals beyond physicians, changed the dosage, changed the number of follow-up visits, made it optional rather than mandatory, among other changes. But one restriction it left in place, the FDA, was that you had to pick up mifepristone at a healthcare facility. So what was interesting about this was mifepristone was the only drug regulated by the FDA with the same restrictions, the same REMS, that you could take by yourself without any supervision, anywhere you chose, but had to pick up at a healthcare facility. And so during the pandemic, a court suspended this rule because it was increasing patient-provider contact. This was a federal district court in Maryland. And in the wake of this ruling, virtual clinics sprung up. And basically what virtual clinics do is just what you'd imagine. They have an asynchronous or synchronous consultation with the patient who comes online, and then they are certified, the providers who run these clinics, to prescribe and mail. And at that point, they were directly mailing pills to patients. On the back of a review following this case, the FDA in 2021 decided it was going to lift the in-person requirement permanently and allow pharmacies to dispense mifepristone if they were certified, which is just procedural verification of that you have the right drug tracking system, blah, 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 blah. I told you we could get into the weeds, but so I teach health law topics, so I'm super excited about FDA regulation, take public health next fall. This ushered in, as Blake said, even more uptake of mailed medication abortion. Now, pharmacies have not rushed to carry mifepristone and to dispense it for the purposes of pregnancy termination where it's legal, but some have. The number of virtual clinics have stayed pretty much the same. But what's really changed is this shield provision of people who are certified to prescribe mifepristone under the FDA rules, who have licenses to be abortion care providers in their home states, mailing medication abortion to patients after a consultation, synchronous or asynchronous or some online form, to any state. So that's the big legal sea change that opened the door for the proliferation of mailed medication abortion. And so I think your question is, and then I want to hop back to HB 7 so people can understand just the ways in which the law creates avenues to hold shield law. Shield providers are those who assist them, or those with the intent to distribute mifepristone and misoprostol. How the law envisions holding those people accountable, because it's quite novel. Yeah.
We go on. I'm sorry, but where does Mexico fit into this situation? In Mexico, are these drugs over the counter? In which case, are they subjected to the same kinds of regulation that you're describing?
No, they are not subjected to the same regulation. Yes, misoprostol is available over the counter, mifepristone is not, but you can end a pregnancy with misoprostol. But mifepristone is much easier to come by in Mexico and in many places. And so one of the things that we could discuss is that up against these, the strategies to end mailed medication abortion, there are as many strategies for it to continue. And one is international pharmacies and networks that provide pills across borders, not just state borders, but international borders. So,
So the question was like, what's being done to attack this FDA approval and the current REMS allowed for mailed mifepristone?
So the first thing is a lawsuit that started here in Texas. The Alliance for Hippocratic Medicine, which you've all read about, likely read about, which was thrown out by the Supreme Court for standing. So the Supreme Court never heard the case on the merits, but essentially it's ongoing, and it's a lawsuit that sues the FDA for approving mifepristone in the first place in 2000 for acting arbitrarily and capriciously on several arguments that the FDA didn't consider the right data and didn't consider it in the right way. And then really hones in on this 2021 change that I told you about. That's why I spent a little time on it, because the lawsuit that went to the Supreme Court and now the lawsuit in the afterlife of the Supreme Court's decision is focused on the harm to states that ban abortion, the harm that is created when there is this market for pills enabled by Shield provision, and targets the FDA's 2021 decision as enabling that market to exist. And so it's a little bit of an attenuated argument of harm, but it is but the claim is that the FDA acted arbitrarily and capriciously, APA standard, when it lifted that restriction requiring in-person pickup of mifepristone. And what's important to watch about that litigation, well, one, for those lawyers of us, the standing arguments, because now Missouri and Kansas have come back with new arguments for why they have standing, even if the Alliance for Hippocratic Medicine did not. And just about a week ago, Louisiana came to court to say, we too sue the FDA because we have standing to sue, and making similar arguments. One, about harm to their quasi-sovereign interests as a state, but also harm, tactile, real, tangible harm to residents who have been either harmed by mifepristone as gauged by studies purporting to show increase in emergency room visits, or harm through coercion. So Louisiana is a case that has added a plaintiff who says that she was tricked into taking pills and ending a pregnancy that she did not want to end. And those combination of harm, both aggregate and individual, are the basis for standing for states like Louisiana. That case was before the district court in Amarillo. It has since been transferred to Missouri. So ongoing, stay tuned. So that's number one. Number two is something embedded in the Alliance litigation, but was prominent in a lot of thinking around abortion law by organizations like the Heritage Foundation, which say, suing the FDA because they acted unlawfully. And one of the reasons the FDA was unlawful is because there is an 1873 act, the Comstock Act, that forbids, criminalizes as a matter of federal law, the mailing of anything, this is in the statute, anything that procures an abortion. And reading this statute, that some of the statute has been repealed as it applies to contraceptives, but the provisions that folks have focused on that still exist in the US Code would, if interpreted in the way that's been suggested, be a national ban on abortion, and not just medication abortion. It certainly would apply to medication abortion because the code is clear that pills are prohibited from being mailed by common carriers. But anything, it is very hard to provide abortion in the United States at present and not have anything not mailed through our mail system. So anything you would use in a procedural abortion. And that has been somewhat quiet now. It's part of the alliance litigation, but we haven't seen efforts from the DOJ at present to enforce the Comstock Act. Just to clarify, and again, sorry for talking.
No, go ahead.
But this act was passed on a wave of anti-vice enthusiasm in the 1870s. It was enforced for the first 40 years of its life with some vigor, mostly because its architect, Anthony Comstock, was the Postmaster General of the United States, and he was really interested in enforcing the act, but was mostly focused on pornography. Like, he was not super interested in the abortion or birth control parts of it, but really, really interested in busting people for pornography. And in fact, he himself ordered tons of pornography and then busted the people who sent it to him. So it was like a trap. So anyway, but then courts started to narrow the reach of Comstock because, as you can imagine, it also led to some mischief. People were using it against each other, for instance, trying to entrap each other in divorce or custody proceedings and the like. And it was narrowed to not be a total ban, but really to and was also had parts of it read out of the law that had First Amendment speech problems. So it's been in disuse for the last 100 years after a series of courts narrowed its interpretation and application. But it could come back. And so that also is part of this tangled up in this FDA argument that has been kind of brewing.
Yeah, and I think the other piece of that is in the civil litigation we're seeing in Texas.
Yeah.
That part of the allegation of wrongful act is also a violation of Comstock Act, and in some of the
Yes.
more recent cases.
In
it's
the wrongful death
Yeah,
acts.
exactly. That you have this violation of the law that is a predicate to the civil action.
Well, let me ask you that question. So there are, outside of the FDA alliance litigation, there's litigation from Attorney General Paxton suing the provider in New York. And now there are two wrongful death suits taken by Texas individuals against a physician in California and others who the wrongful death tort action here includes the wrongful death of the unborn, and it's on the back of that this suit has taken place. And I'm wondering if you could walk us through how that differs from, for instance, SB 8, private individuals suing under SB 8, and HB 7, which creates a key TAM action for an individual, which is different from the action in SB 8. For someone to sue to vindicate the interest of the state of Texas. So can you help us understand these three pockets of individual action?
Maybe I can explain it the best I can, but I think the important thing to think about when you're thinking about the differences between the three classes of plaintiffs it creates basically is not how they're being used currently, but really what they were intended to get at originally. So originally we had a wrongful death statute, which was just statutory tort law for the families of people who have died due to someone else's negligence. Just kind of as simple as that. In the early, I can't remember now, in the late 90s or early aughts, that statute was changed to include quote unquote unborn child. So the loss of a pregnancy was also actionable under the Wrongful Death Act, which is like the presage to all the fetal personhood that we see in the code today. And so that really allows this kind of narrow set of family members to bring a cause of action against someone who has done some wrongful act that caused the death. So you sort of have to have this predicate wrongful act to start with. And it could be anything. It could be negligence in a car wreck. It could be something that's criminally illegal, but you have to have that predicate wrongful act. And so that's how the wrongful death statute came to be. And then Senate Bill 8, it famously creates this private cause of action, but it created it for a different purpose, which was to escape pre-enforcement review by the courts, because this was in a world where Roe versus Wade was still the law of the land. Abortion, states couldn't really ban abortion. The Dobbs case was working its way through, but it was really an attempt to, Texas had already had its previous restrictions on abortion care tossed by the Supreme Court in Holman's Health versus Hellerstedt. So Texas is trying to figure out, okay, what else can we do to prohibit and restrict abortion? And so their best idea was, instead of trying to thread the needle of what Casey said was an undue burden and think of restrictions that weren't undue burdens, they said, well, what if we just make a law that avoids judicial review or avoids implicating government action, so then there's no civil rights violation, there's no redress for the pregnant person or the physician under the Roe and Casey framework. So that's why Senate Bill 8 contains this private cause of action. Its intent was really to avoid judicial review, and also because by having a private cause of action, you didn't have a state actor who could be sued. So you didn't have the state violating your civil rights. You just had private litigation among individuals. So the point of its private cause of action was really about avoiding review in an era where there was still a constitutional right to abortion, right? And the state in litigation defending Senate Bill 8 kind of went to great pains to say there is no state activity, there can be no state enforcement, there's no state interest, absolutely not. But now, as you've said, the state of Texas would really prefer that it could assert its quasi-sovereign interest against the state of New York, right? And it really wants to set up this fight about full faith and credit. And it can't really do that if it continues to disclaim any interest in this litigation, which is why House Bill 7 frames, that's why I think so, I don't think anyone said it explicitly, but House Bill 7 frames its cause of action as qui tam, because then that is in the mode of...
Can you explain qui tam?
Yeah, so a qui tam action is where a plaintiff, or in the case of those actions, a realtor, sues someone to vindicate the interests of the state. It happens a lot if you think of like whistleblower suits, like somebody's doing something wrong, it's harming the state. It happens a lot in...
It's like fraud.
Yeah, that's what I was gonna say. In healthcare, in government-run healthcare programs, fraud, that this is being wasted, that these are fraudulent claims, the state is losing this money by paying them. And part of the encouragement for qui tam and whistleblower lawsuits is that the person bringing the action on behalf of the state's interest gets to keep a portion of the recovery. So House Bill 7 has framed this cause of action as a qui tam action, I think, so that in the future they can say, well, this is really the state's sovereign interest being protected. And New York, Massachusetts, California, these other 8 states that have these shield laws, you have to respect our interest in enforcing this law. It's not just this individual. So that's sort of like the 3 different ways the private causes of action are slightly different and are attempting to achieve different purposes, I think.
Yeah. Yeah, and I think that the wrongful death suits, those tort claims, they haven't, they've just been filed, so we don't know they're, for instance, one's before the Federal District Court in Galveston, which brings up its own set of really interesting issues about, the federal court's treatment of a state shield law. Especially if it's used as a defense in litigation that involves a state tort claim. So we also have some eerie kinds of questions. You're getting it all today. Con law, CIPRO, crim law, all of it, health law. The lawsuit that was brought by Texas against the New York doctor is also making its way through courts. As I think I mentioned, the county court clerk in New York has refused to enter the motion that would result in the enforcement of the judgment against the doctor. And so we're gonna see some more action there, as Blake said. This, I think, tees up an argument for Texas to make around full faith and credit, and New York to make an argument that there is an exception to the full faith and credit clause, the penal exception, which this case should fall under. And in brief, that is the idea that the full faith and credit clause does not cover civil judgments that act as if they are punishments. So they are not judgments that attempt to compensate someone for a wrong, but are really judgments that seek to implement the public policy of another state through a fine that acts as a punishment on the person who violates that public policy. It's not an area of law that abortion has been particularly intertwined in, but it's certainly will result in a number of questions. So we've got 10 minutes left, and maybe we should open it to questions.
Yeah, does a key tam cause of action automatically run afoul of the penal exception for to the full faith and credit clause? Because if it's for cause of action for the state, does that mean it's not like compensating a private individual?
Well, I mean, that's a good question, because the posture would be you sue a doctor, let's say in another state under HB 7. You say that doctor is mailing pills into the state, and we can talk about how some of the things that have happened in response to the other side of these suits of people who, states that are now removing identifying information from prescription bottles in response. But you take the action, you win in state court. So what this hinges on is that you are successful and showing a case under HB 7, and you win a judgment, and like the physician in New York, you seek to enforce it, but there's nothing to enforce in Texas. The person has no assets here, they've never traveled here, I think it's a little hard. It's different, but it would be the same argument if a state, after judgment in a Texas court, refuses to enforce the order. I don't know how it cuts, if it's a stronger or not a strong argument, given it's a key tam.
I think it maybe is in some of both ways, because you could make the argument that because it's a key tam, it's really about the state punishing for its policy preferences. So you're within that exception, especially when there's no, like, what we think of as like hard economic damages. Like the state is not saying it's out any money because the doctors did that. So it really is into that realm of punishment and not compensation. But it's hard. I don't think it would be like a de facto because it's key tam, then it's definitely this or that. I think it's like a fact-based inquiry for the court.
I think it's really interesting that these are strategies that inform each other, because at the crux of the alliance litigation is an economic argument that there are studies that seek to show that there's an increase in emergency room visits, and that increases the cost of state hospitals, and the state then bears that cost. So there's a real economic harm that the state is attempting to redress. That wasn't enough for standing, so it may not be enough for the kind of compensatory harm that a court would look to in thinking about this. Is this penal exception, is it not? But I want to underscore that this is a very underdeveloped area of law. And there are no clear answers about, for sure, New York has a slam dunk case, for sure, Texas has a slam dunk case. And so, but yeah.
Which I think is why they're an attempt at multiple strategies of teeing it up in different courts to see how it shakes out and what their strongest case is as it goes through. Because I think we'll see this choice of law question that you mentioned about the federal court in Galveston is really interesting, like the Erie question, because I think we're going to see that in HB7 litigation, because I think some of those cases will be brought in federal court because there'll be diversity jurisdiction.
Yeah.
So I think we'll see cases in the federal court in Amarillo, for instance, or other districts in Texas with some judges that are maybe friendly or predisposed to
Right.
those arguments,
There will also be jurisdiction problems as this chain of distribution if it gets too broad, right? Trying to sue the drug manufacturer, trying to sue an online pharmacy. It's going to be hard. It'll be harder to make the jurisdiction argument than it would be for a provider. But for the wrongful death tort suits, I think you've got a real problem applying the penal exception there, because that's like classic, but maybe not. Other questions?
Oh, sorry. You go. Well, it's just a clarification question, just to wrap up this last one. You said, think you have a real problem with penal exception and the wrongful death suits. Which way did you mean that?
I meant that if you win a tort case, you're gonna have trouble when someone says enforce this in another state. It's gonna be hard, I think, to make an argument that full faith and credit doesn't apply. I think it's a clearer case of full faith and credit applying.
Okay.
Yeah.
And you think that's the clearest cut opportunity to like pierce the shield law? Like you can put it that way, like if the judgment for this tort is against the provider.
So it's trade-offs. You can enforce the judgment, but it's going to be a one-off with no precedential value. Versus Paxton winning in New York based on all of it could have a chilling effect for people living in New York who are mailing pills somewhere else. I mean, and also that's what HB7 could as well. But the wrongful death tort claim will be against a provider for one person's facts scenario, and it won't necessarily mean anything for, the other person who blah, 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 blah. Versus, a suit against the state of New York by Texas that their shield law is in violation of the US Constitution could threaten shield laws across the country. So I think it's scale and scope that differ.
Were there any other changes in the recent legislature on abortion other than the prohibition on mailing from out of state?
The kind of clarification of the medical emergency exception that I mentioned a little bit. And then also in the past few years, the city of Austin and the city of San Antonio have used part of their budget to provide contracts to practical support organizations that helped people get out of state for care. And the legislature prohibited governmental entities from doing that. Yeah, that's right.
Yeah, SB 31 we've been working on it's going to require continuing medical education and continuing legal education on Texas's abortion law. And so there's a lot of discussion about how to best communicate what the law requires in the state, particularly after Zarowski in this case.
Hi, I work for Lilith Membership Funds, and I'm curious if you could talk a little bit about how things have kind of shaped out in regards to HB7 in terms of how it impacts the abortion funds specifically. I feel like the main concern was about kind of this intent and like how that could maybe be applied to funding sources for abortion access like out of state. And if anything has kind of come to clarity regarding that.
It's a good question because there's no real clarity about it. So it's important to keep in mind that the bill prohibits the intent to violate the prohibition, which is mailing, prescribing, providing abortion into or from Texas. So the best plain reading of that is that providing funding for someone to travel is not providing, prescribing, whatever, the pills from Texas. That's something totally different, right? So that definitionally isn't a problem. And you have this right to travel issue that it couldn't really, even if it meant that, you probably have a constitutional right to do that and it couldn't be enforced, right? That's what the federal court here said. That's what the federal court in Alabama said, the Yellowhammer case. So it really doesn't implicate that. Then the question is, well, what about funding the care itself in another state? Is that definitionally if you're providing the money from Texas and the care somewhere else, does that mean you're providing it from? And that's like an open legal question.
Yeah.
You know.
Earlier versions of the bill did have much broader language and included
Oh, yeah.
internet providers and websites and, and those disappeared from the bill that was enacted.
Yeah, the bill that's enacted really ends up being very narrow to like thread the needle to, I think, accomplish these 4 or 5 things to like really be able to get to the out-of-state providers in specific ways.
Thank you all. Thanks for spending your